Schemes.
Michael A. Cronin, 73824, I'm gonna have to find your honor.
Lisa, I don't know who gets this case. I guess it probably goes to me. Your name?
Joshua Michael.
Where you been? You're supposed to be here a year ago.
I understand that, sir. I'm not gonna make any excuses for that. Right now, currently, I'm in a Monroe County Circuit Court of Drug Court with, Judge Nichols. I also have a letter from.
Oh, okay.
Your honor, I put a copy of the letter in the file, that's for the court to keep and review. Last October, when my client had his court date, he was using, and he makes no excuses for that. But he's been in drug treatment court, as the court can see through that letter, since March. He anticipates that to continue until next July. And looking at the letter, he's doing really well.
Okay, good enough.
The court coordinator signed it. This offense was 2 years ago. He obviously needs to have it adjudicated and continue his good work in down in Monroe with Thursday.
All right. I don't believe he ever was printed on this case.
No, sir.
Why didn't you go and get printed? Somebody signed the order.
I'm not gonna make excuses, but I live down in Monroe and it was a problem for me to get a ride. But right now, I'm working with RAW, which is a recovery advocacy warriors, and they provide transportation. And that's who actually brought me here today.
Lisa, I'm gonna need an order for prints. I need a new bond sheet. How long you been in their drug court?
Since March.
Why didn't you come in here earlier?
No excuse. I knew I had the warrant.
Didn't they tell you to come in here?
They did. That's why I'm here today.
Well, it was March.
Yeah. It was.
I swear, I think we're operating a five-star restaurant here sometimes.
Your Honor, as my client indicated, he can't get a ride, and he got a ride from, it's called Recovery Advocacy Warriors. They provided the right service for him here today.
I don't want to hear about rides. I get so tired of hearing about rides. I don't have a ride. They had a ride to get here. They lived here. But all of a sudden, the whole criminal justice system's worried about rides. They don't have to get a ride to court. They don't have to. Jeez. Lisa, print out me another. I'm going to give you a $10,000 personal bond. Lisa, print me out another order. You have to go over and get fingerprinted and photographed today. Do you understand that, sir?
Yes.
By 2 p.m. at the Michigan State Police Post. Was this a Taylor case out of the Taylor Post Council? Do you know?
It was right.
So you have to go over there today, defendant to comply, not to consume alcohol, marijuana, or illegal drugs, to comply with all terms and conditions of Monroe Drug Court, okay?
Yes, sir.
If you weren't in there, you'd be sitting in jail probably. You can't do this.
I understand, sir.
All right. So that's what I'll do. We're going to give you an order for prints. You're going to take that order over there. Do not leave until you get it. I will give you a new court date. We will give you a pretrial date on September.
How long do you want to
24th.
go?
23rd is good.
All right, 23rd at 9:30.
Okay. And then just send down the order for prints if you can, or give it to John and I'll sign it, okay? So you have to go over there. Don't leave until I give you the order for prints in the bond sheet, okay? Any questions?
No, sir.
If you want a lawyer going forward, you fill out a petition for a court-appointed lawyer, all right?
Yes, sir. Or I might have done it before in October.
A year ago, I know, but this is 25, September of 25. It's 11 months later. You might have hit the lottery. I don't know which. All right, that's what I'm doing. Good luck. Thank you.
Yes, sir. I appreciate it.
What are you laughing about?
Those highway portions.
All right. What else do we get up here? did they get a hold of Detective Strong or Officer Trooper Strong? Brown, rather.
Carl said he's got a boatload of stuff in front of Judge McNally or Judge Gus.
Scheduled a bunch of stuff today. I don't know how long it's gonna be.
Why am I? Ma'am, I can either reschedule this. Come on back up here. Robin Michelle Barnett, 25M 549 453. Your name?
Robin M. Barnett.
So, I mean, what's fair is fair. I know you had an excuse. I'm setting aside the default judgment. But I can't dismiss it. He's in another court. If you want, I mean, he's next door. If you can either wait or I'll reschedule it in a week or two and let you.
Would like,
No, it doesn't matter to me. It's more your convenience. I'm here either way. If you want to wait, fine. If you don't, I understand. You've been here for an hour and I'll be glad to reschedule it in a week or two.
if I can wait, if it's not,
I don't know how long it's gonna be.
Schedule.
Don't worry about me. Don't worry about me. Okay? I'm fine with it. I just hate to see you wait. It sounds like he's got a boatload of them over there, okay?
Okay.
So it might be a while. So, all right, have a seat, and as soon as he's ready, I'll call it, okay?
Okay.
Thank you.
Can I ask if it would be a problem if I did a little work on my cell phone if there's no bathroom on it?
No problem.
Okay.
Thank you for advice of rights form today. He didn't, did he?
He did not.
Just try to make sure they always sign it.
Understood, Chuck.
You're presumed innocent. They have to prove you guilty, John. Beyond a reasonable doubt, you have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. And we are not going to have a trial of any kind. Do you understand that, sir?
Yes, sir.
All right. Take your time. Make sure you read those. Make sure you understand those. We're going to go off the record momentarily. And then I'll go back on record when you've read those.
Chuck, I'll bring it inside real quick.
Recalling, Demps. Counsel. This is, Kale Quatez Demps, 25B 706-301. Your name?
Michael A. Carmen, B738 I'm at the front.
So I don't know if I got accurate information, but 12 minutes ago, I was told he was 5 minutes out. And then I had them check. I'm not saying, I don't know who told me that. I didn't. Did you say 5 minutes before, John?
Only 5 minutes, and then when the first time I called, it was 5 minutes. Then I called again, said 10 minutes.
So,
Well, when I said 10 minutes, I said originally his ETA was 11:15, 11:20.
Okay,
I called
okay,
5
okay.
minutes ago, he said 10 minutes.
well, he said he was in Howell, right? He got off the phone, well, off the Zoom at 9:30.
He had to drive his work truck to a yard in Trenton and get his personal vehicle and fix it. It should just be a couple more minutes, Your Honor.
All right, but you're convinced he is on his way. He's not just playing a game. I mean,
Sign
I got it. Okay, good enough. And we'll go from there. Thank you.
Well,
These guys make it. Yeah, I'm gonna be right with you too, ma'am. Ms. Washington, we went off record and I'll come back to you, okay?
Okay.
All right, back on record on Grace. Recalling Drew Deshaun Grayson, 25G 719-663. Ms. Washington, your name?
John in Washington.
Ms. Graziani?
John Graziani, appearing on behalf of Drew Grayson.
Mr. Grayson, your name?
Drew Grayson.
So again, I'll start again. You're going to plead, he's going to plead under 76948 to domestic violence. Is that true? Is that true?
Yes.
If you do that, the possible penalties are up to 500 fines, 93 days jail. Costs are all those. I'll defer the proceedings, set terms. If you're compliant at the end of a specified period, the case will be dismissed. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand all of that? All right. To the charge of domestic violence, how do you plead?
Guilty.
You got to keep your voice up.
Guilty.
On August 18 of 25, were you at 19646 Homestead Lane in the city of Gibraltar?
Yes,
Were
sir.
you married to Joan A. Washington?
Yes, sir.
What did you do that makes you guilty of an assault or assault and battery?
Place my hand.
You got to be more specific than that.
Place my hand over her mouth. Without.
Was she yelling?
Yes, Your Honor.
Was she raising her voice? Let me put it to you there.
Yes, Your Honor.
And so in an attempt to get her to stop, you put your hand over her mouth.
Yes, Your Honor.
Did you push her?
Yes, Your Honor.
Did you slap her or punch her?
No, Your Honor.
When you pushed her, was it a forceful or violent touching?
Forceful touching.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No, Your Honor.
Were you under the influence of alcohol or narcotics?
No, sir.
You hadn't consumed anything at all, drugs or alcohol?
No, sir.
All right, I'm going to take your plea under 7694A. I find the plea has been made voluntarily and understandingly. And I'm going to order a pre-sentence report. And then, ma'am, I'm going to listen to you. I want you to come back on the date of sentencing. We're going to notify you as to what that date is now, and probation will send you a victim's rights statement. And you have the right to make a written statement. You also have the right to make a verbal statement. I certainly hope that you'll show up here for sentencing, okay?
Yes, Your Honor.
Okay, what day are we going to do that, Lisa?
September 23rd at 8:30.
Okay, September 23rd at 8:30 in the morning, all right?
Judge, I have no problem with that, but you
Yes.
give them sufficient time for the interview.
Oh, yeah. We got a very,
Okay,
Yeah, I know.
you have a great staff, Judge, but I just want to make sure.
I appreciate it. Well, no, they'll have it done.
Okay.
So ma'am, make sure you show up that day, 2 weeks from today, September 23rd, 8:30, okay?
Yes, Your Honor.
Thank you.
Thank you.
Hensley.
All right, let's talk about that. This hearing in Judge Middleton's courtroom turned into a double feature: a probation violation that nearly ended in jail and a domestic violence plea that showed how deferments work. Was Nicholas Horn, back on probation with 3 fresh technical violations for failing to submit to his SoberLink breath tests. That might sound minor, but Middleton reminded him that with prior violations on his record, he could be looking at a year behind bars. Horn admitted missing tests on 3 separate dates, blaming his unusual work schedule at a Detroit restaurant and falling asleep while putting his kids to bed. His attorney argued hard that Horn wasn't a bum dodging responsibility. He had kids, a job, and was spending hundreds on Ubers to get to work. But the probation officer pushed back, saying Horn had been warned repeatedly and still wasn't complying. The judge's skepticism was obvious. Horn claimed he couldn't afford the $100 setup fee for a scram tether until Friday, yet also admitted he had prepaid for a family trip to North Carolina. Middleton zeroed in on that contradiction, bluntly telling him, "Your priorities aren't in line." Still, rather than revoke probation outright, the judge gave him one last chance. Switch from SoberLink to Scram by September 12th, keep testing in the meantime, and remember he was incredibly close to a year in jail. It was firm, with just a sliver of mercy. Then came Drew Grayson, who pled guilty under a deferred statute to a domestic violence charge involving his wife, Joanie Washington. Grayson admitted that during an argument, he put his hand over her mouth to stop her from yelling and pushed her. Middleton pressed him to be specific. Was it a forceful or violent touching? And Grayson said yes. The plea means no trial, but also no immediate conviction. If Grayson follows probation terms, the case can be dismissed at the end of the period. The judge set sentencing for 2 weeks later, ordered a presentence report, and emphasized to Washington that she'd have a chance to submit a victim impact statement and speak in court. The atmosphere throughout was sober and pragmatic. Horn's case showed Middleton's blend of dry skepticism and conditional patience, willing to give a last chance, but unwilling to buy excuses. Grayson's case showed the mechanics of a deferred plea, with the judge carefully walking through admissions and victim rights. Time to break this one down. Middleton gave one defendant a razor-thin margin to stay out of jail and another a chance to earn a dismissal. But in both cases, he underscored the same message: compliance isn't optional. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.